I've talked about what's called intestate transfers. When you pass away and you don't have a will, then California has laws that determine how your property will be transferred. So I wanted to give a little bit more detail. So in California, we are a community property state. That means there is property that is property that belongs to the community is based upon income that you've earned or property purchased during marriage that comes from other community property. So if you've been earning money during marriage and then you go out and buy a house, or you go out and buy stocks, or you buy a income property like a building, that is all community property. Separate property is money that is earned before marriage or after legal separation, and separate property also, in order to maintain its status as separate property, cannot be funded by money from the community, or the community can't do work on the separate asset. Because again, if you work during when you're married, any work you do should be considered part of the community. So if you manage your separate properties, then the law says you are slowly changing that separate property into community property. But if you, for example, bought some income property, and the rents for the income property pay for the mortgage on that, and then you get married and somebody else is managing it, and any money that's owed on it or any property taxes are paid for out of income from that separate property or some other separate property. Let's say your parents give you money to pay and they give it to you separate property, and that pays for the property tax every year. So that stays your separate property. So there's community property and separate property.